maybe she gave it to me.
All right, we're on the record. Let the record reflect that the defendant is present with his attorney, the state is present, we are outside the presence of the jury. Now, the court has prepared its charge, which the court will read shortly to the jury. Has the state had an opportunity to review the court's charge?
Yes.
Does the state have any objections to the charge?
No.
Has the defense had an opportunity to review the court's charge?
We have none.
Do you have any objections to the court's charge?
No, ma'am, we have no objections to the charge as written.
All right. Are both sides ready to proceed with closing arguments?
Yes, sir. Yes, ma'am.
Judge, we had this issue we wanted to bring up.
Yes, that's correct. So I wanted to make sure that we're all ready to
Oh, yeah, we're
move forward after that.
subject to that, we're ready. We are.
Okay, all right, and this does not need to be, broadcast by the media. We have a juror who was, late to the proceedings, and both sides have concerns about this particular juror. And the court's bailiff also had an encounter with the, said juror, out in the hallway, is that correct, Deputy Jernigan? All right. Do both sides wish to question this juror?
Only if the court wants to. I don't know what you're privy to with the bailiff, but based on what I've stated to the court, I don't have a need to. I don't know what they want to do.
About the defense?
Your Honor, we would request that the court inquire, and not in either of the parties. I don't think it would be appropriate for the parties to inquire. He may take offense to some, either side of the council asking personal questions
Okay.
in that regard. I think it
All right,
could interfere with his deliberative process.
okay,
I agree, but I would like to give you what I know so that you can
all right,
form your questions. And I don't know what the bailiff knows. That's something else that we don't know.
all right, go ahead. Go ahead and state your, issues or your concerns.
Okay, so you, as I understand, you instructed the jurors to be back at 10. This was about 10:30-ish. And I was coming into the courtroom, and some of the family members asked me about when they could enter the courtroom, and I said, I don't know. And they said, what about him? And I didn't know who him was, and I said, who are you talking about? And they said, him. And when I turned within 2 or 3 inches of me, and I don't know his name, he's the man with the mask, I'm sorry, I don't know his name, nor do I know his number, but in any event, he was right at me, staring at me in the face, and I could, at that moment, I could smell alcohol. And what I have told the court, and want the court to know, and on the record, that at least on 2 other occasions, he's been in the courtroom when he should have been back there. He's come up to me, lost, looking confused, and I've taken him to that outside door to go back. I don't know what he did after that. There was at least one other time when you had cleared the courtroom and we want to recess for whatever, I don't remember. He came in the courtroom and sat down, which I know you don't want. And so I said, sir, you need to go through that door and take a right. And he did. So I've had probably 3 encounters with him, but the most important one I think is just a few minutes ago where I could definitely smell, because he was literally, I mean, if I had moved 2 inches, I would have touched his nose or so. And I could smell alcohol on him.
Thank you.
Okay.
All right, does the defense have any,
Your Honor,
observations?
Well, no, Your Honor, the juror would only be disqualified if he was intoxicated and unable to perform his duties. I don't
I'm
know.
sorry, say that again?
I said, it's my understanding that the juror would only be disqualified if he was found by the court to be in an intoxicated state and unable to perform his duties. So I think there's 2 separate issues. One is alcohol, although it's certainly not what you would expect or hope for in a juror. But I don't believe a alcohol on your breath is sufficient to disqualify you as a juror. It'd have to be that you were intoxicated and unable to perform your duties. And I think that would be necessary for the court to inquire and may base its opinion.
Okay, thank you. And, Deputy Jernigan,
Yes, ma'am?
do you swear that the information you give the court will be the truth, the whole truth, and nothing but the truth to help you God?
I do, Your Honor.
Thank you. So, what were your observations, if any, of this particular juror?
Well, Judge, I did not smell any alcohol, and he seems a little bit incoherent to demands and orders when I tell him to come in, which entrance to come in. He always comes through the front door, and I told him at least 4 times to come through the juror's entrance side. So, but other than that, he's just complaining of backache, so he may be taking medication for his back pain, because he said he's in extreme pain.
Okay, all right, thank you. Kindly bring that juror into the court.
Yes, ma'am.
May I make an additional request?
Hold on, Deputy.
Yes, ma'am.
May I make an additional request?
Yes,
Based on what the sheriff has indicated, I think there's also an issue of whether he can and has, or can certainly participate by giving his full undivided attention. If he's in pain and can't find where he needs to be, obviously that may be an issue. So I'm just asking the court to consider that in its questions.
okay.
Okay.
Go ahead, Deputy.
It's just, we do not have any media involved in this.
No, we do not. I've instructed the media not to, report this. order on the record. Let the record reflect that the defendant is present with his attorney. The state is present and the jurors are present and seated. Good morning, ladies and gentlemen.
Good morning.
Thank you all so much for your patience. I know we took longer than we anticipated, but we were working hard on the court's charge. And also waiting on one of you to arrive, okay? So, both sides are ready to proceed at this point. You have, the evidence, but now I'm going to give you the charge that contains the law that will guide you during your deliberations. And I will read it to you, but you'll be given a copy to take with you, to the deliberation room in case you need to refer to it afterwards. All right, in the state of Texas versus Nestor Hernandez, charge of the court. Members of the jury, the defendant, Nestor Hernandez, stands charged by indictment with the offense of capital murder, alleged to have been committed on or about the 22nd day of October 2022 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. You are instructed that the applicable law to this case is as follows. A person commits the offense of murder when he intentionally or knowingly causes the death of an individual. A person commits the offense of capital murder if he commits murder, as defined above, and the person murders more than one person, A, during the same criminal transaction, or B, during different criminal transactions, but the murders are committed pursuant to the same scheme or course of conduct. Term definitions. Act means a bodily movement, whether voluntary or involuntary, and includes speech. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Individual means a human being who is alive. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Mental state definitions. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he's aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. A person acts with criminal negligence or is criminally negligent with respect to the result of his conduct when he ought to be aware of a substantial and unjustifiable risk that the result complained of will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the standpoint of the person charged. Capital murder. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October AD 2022, in Dallas County, Texas, intentionally or knowingly caused the death of Jacqueline Pekua, an individual, by shooting Jacqueline Pekua with a firearm, a deadly weapon, and during the same criminal transaction, said defendant did then and there intentionally or knowingly cause the death of Katie Flowers, an individual, by shooting Katie Flowers with a firearm or a deadly weapon. Or the defendant, Nestor Hernandez, on or about the 22nd day of October 2022 in Dallas County, Texas, intentionally or knowingly caused the death of Jacqueline Pekua, an individual, by shooting Jacqueline Pekua with a firearm, a deadly weapon, and during a different criminal transaction, but pursuant to the same scheme and cause of conduct, said defendant did then and there intentionally or knowingly cause the death of Katie Flowers, an individual, by shooting Katie Flowers with a firearm, a deadly weapon, then you will find the defendant guilty of capital murder as charged in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of capital murder as alleged in the indictment, and say by your verdict, not guilty, and proceed to consider whether the defendant is guilty of the lesser included offense of murder of Jacqueline Pekua as included in the indictment and outlined below. Lesser included offense of murder, Jacqueline Pekua. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October 2022, in the County of Dallas, State of Texas, intentionally or knowingly caused the death of an individual, Jacqueline Pekua, the deceased, by shooting the deceased with a firearm, a deadly weapon, then you will find the defendant, Nestor Hernandez, guilty of murder of Jacqueline Pekua as included in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of murder of Jacqueline Pekua as included in the indictment, to say by your verdict, not guilty, and proceed to consider whether the defendant is guilty of the lesser included offense of murder of Katie Flowers, as included in the indictment and outlined below. Lesser included offense of murder, Katie Flowers. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October 2022 in the County of Dallas, State of Texas, intentionally or knowingly caused the death of an individual, Katie Flowers, the deceased, by shooting the deceased with a firearm, a deadly weapon, then you will find the defendant, Nestor Hernandez, guilty of murder of Katie Flowers as included in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of the murder of Katie Flowers as included in the indictment, say by your verdict not guilty, and proceed to consider whether the defendant is guilty of the lesser included offense of manslaughter of Jacqueline Pekua as included in the indictment and outlined below. Lesser included offense of manslaughter, Jacqueline Pekua. You are instructed that a person commits the offense of manslaughter if he recklessly causes the death of an individual. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October 2022, did recklessly cause the death of an individual, namely Jacqueline Pekua, the deceased, by shooting the deceased with a firearm, a deadly weapon, then you will find the defendant guilty of manslaughter as included in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of the manslaughter of Jacqueline Pekua as included in the indictment, and say by your verdict, not guilty, and proceed to consider whether the defendant is guilty of the lesser included offense of manslaughter of Katie Flowers as included in the indictment and outlined below. Lesser included offense of manslaughter, Katie Flowers. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October 2022, did recklessly cause the death of an individual, namely Katie Flowers, the deceased, by shooting the deceased with a firearm, a deadly weapon, then you will find the defendant guilty of manslaughter as included in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of manslaughter of Katie Flowers as included in the indictment, say by your verdict not guilty, and proceed to consider whether the defendant is guilty of the lesser included offense of criminally negligent homicide of Jacqueline Pekua as included in the indictment and outlined below. Lesser included offense of criminally negligent homicide. Jacqueline Pekua. You are instructed that a person commits an offense of criminally negligent homicide if he causes the death of an individual by criminal negligence, as that term has been defined. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October 2022, did cause the death of an individual, namely Jacqueline Pekua, the deceased, by criminal negligence, then you will find the defendant guilty of criminally negligent homicide as included in the indictment. But if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of the criminally negligent homicide of Jacqueline Pekua as included in the indictment, say by your verdict not guilty, and proceed to consider whether the defendant is guilty of the lesser included offense of criminally negligent homicide of Katie Flowers as included in the indictment and outlined below. Lesser included offense of criminally negligent homicide, Katie Flowers. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that the defendant, Nestor Hernandez, on or about the 22nd day of October 2022, did cause the death of an individual, namely Katie Flowers, the deceased, by criminal negligence, then you will find the defendant guilty of criminally negligent homicide as included in the indictment. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either capital murder or the murder of Jacqueline Pekua or the murder of Katie Flowers, but you have a reasonable doubt as to which of said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser included offense of murder of either Jacqueline Pekua or Katie Flowers. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either the murder of Jacqueline Pekua or the murder of Katie Flowers, or manslaughter of Jacqueline Pekua or manslaughter of Katie Flowers, but you have a reasonable doubt as to which of said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense of manslaughter of either Jacqueline Pekua or Katie Flowers. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either manslaughter of Jacqueline Pekua or manslaughter of Katie Flowers, or criminally negligent homicide of Jacqueline Pekua or criminally negligent homicide of Katie Flowers, but you have a reasonable doubt as to which of said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense of criminally negligent homicide of either Jacqueline Pekua or Katie Flowers. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either capital murder, murder of Jacqueline Pekua or murder of Katie Flowers, manslaughter of Jacqueline Pekua or manslaughter of Katie Flowers, or criminally negligent homicide of Jacqueline Pekua or criminally negligent homicide of Katie Flowers, but you have a reasonable doubt as to which of said offenses he is guilty, then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense of criminally negligent homicide of either Jacqueline Pekua or Katie Flowers. If you have a reasonable doubt as to whether the defendant is guilty of any offense defined in this charge, then you will acquit the defendant and say by your verdict, not guilty. Indictment. An indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that a person has been arrested, confined, indicted for, or otherwise charged with an offense does not give rise to any inference of guilt in the trial. Presumption of innocence. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. Burden of proof. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubts concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Evidentiary instructions. You are instructed that if there is any evidence before you in this case regarding the defendant's having committed any offense other than the offense alleged against him in the indictment in this case, you cannot consider said evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any. Even then, you may only consider the same in determining the state of mind of the defendant, motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident of the defendant, if any, in connection with the offense alleged against him in this indictment. You are instructed that certain evidence was admitted in evidence before you in regard to the defendant's having been charged and convicted of offenses other than the one for which he is now on trial. Such evidence cannot be considered by you against the defendant as any evidence of guilt in this case. Said evidence was admitted before you for the purpose of aiding you, if it does, in passing upon the weight you will give his testimony, and you will not consider the same for any other purpose. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain evidence might properly be admitted. You are not to be concerned with the reasons for such rulings, and are not to draw any inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court neither determines what weight should be given such evidence, nor passes on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you, of course, must not consider same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been, or as to the reason for the objection. You are the exclusive judges of the facts proved, the credibility of the witnesses, and the weight to be given the testimony. However, you must receive and follow the law provided to you by the court. You are instructed that you may consider all relevant facts and circumstances surrounding the death, if any, and the previous relationship existing between the accused and the deceased, together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense, if any. Deliberation instructions. After you retire to the jury room, you should select one of your members as your presiding juror. It is his or her duty to preside at your deliberations, vote with you, and when you have unanimously agreed upon a verdict, to certify to your verdict by using the appropriate form attached hereto and signing the same as presiding juror. Your verdict must be unanimous and shall be arrived at by due deliberations and not by majority vote or any method or chance. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case from any source other than the witness stand. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the laws as stated to you by the court in these instructions are to be wholly disregarded. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. During your deliberations, you are also instructed you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, such as Facebook, Snapchat, LinkedIn, YouTube, Instagram, TikTok, or Twitter, to communicate to anyone any information about this case, or conduct any research about this case until I accept your verdict, if any. After you have retired to consider your verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in his or her charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause, and restrict your deliberations solely to the issue of guilt or innocence of the defendant. If you have a verdict, or if you wish to have a break, turn on the red light, and the bailiff will quickly respond. And this is signed by me, Judge Chika Anu, Criminal District Court Number 7. And on the back of the instructions, you have the verdict forms, and I'm going to read them out to you. All right, the first one, the State of Texas versus Nestor Hernandez. We, the jury, unanimously find the defendant guilty of the offense of capital murder as charged in the indictment. Presiding juror's signature, presiding juror's printed name. Or, we, the jury, unanimously find the defendant guilty of the lesser included offense of murder of Jacqueline Pakua as included in the indictment. Signed by the presiding juror, printed name of the presiding juror. Or, we, the jury, unanimously find the defendant guilty of the lesser included offense of murder of Katie Flowers, as included in the indictment. Signed by the presiding juror, printed name of the presiding juror. Or, we, the jury, unanimously find the defendant guilty of the lesser included offense of manslaughter of Jacqueline Pakua, as included in the indictment. Signed by the presiding juror, printed name of the presiding juror. Or, we, the jury, unanimously find the defendant guilty of the lesser included offense of manslaughter of Katie Flowers, as included in the indictment. Signed by the presiding juror, printed name of the presiding juror. Or, we, the jury, unanimously find the defendant guilty of the lesser included offense of criminally negligent homicide of Jacqueline Pakua, as included in the indictment. Signed by the presiding juror, printed name of the presiding juror. Or, we, the jury, unanimously find the defendant guilty of the lesser included offense of criminally negligent homicide of Katie Flowers, as included in the indictment. Signed by the presiding juror, printed name of the presiding juror. Or, we, the jury, unanimously find the defendant not guilty. Signed by the presiding juror, printed name of the presiding juror. Now, as I said, I'll give you this charge so you can refer to it. I know there's a lot in there, but it will guide you. If you need to refer to it, please do so. Well, you do. Having read the charge, is the State of Texas ready to proceed with closing argument?
I am, but I need to ask if we can approach you from literally 5 seconds.
Yes, of course.
We started talking about some very important things, and we'll run through them, and then we'll get to the facts of this case and why we're here and what this case is, okay? We came here and we thank you for coming. We thank you for responding to the summons. Many, many summonses go out and very few show up. But we also gave you an oath, and we went over that and made certain that you understood that your oath in talking to us was very special because we're Americans and this is how our system is built. And then I told you that the judge would have you stand up when we started this phase of the case and give you another oath that you will a true verdict render according to the law and the evidence, so help you God. And we have here, the law is written, and the evidence, obviously, that you are to consider came from this witness stand or off of that screen or in documents or whatever. That's the evidence that you are to use and nothing else, okay? We talked about capital murder. And we talked about the law surrounding that in the 2 different ways, at least that we posted up for this particular case, that capital murder can be committed. Okay? The defense talked about murder as a lesser included offense, but we focused on what was in the indictment. Okay? The judge is giving you some instructions. And I want to talk about some of these because, first of all, as we said, this is the law. And on page 4, after your consideration of whether or not we prove capital murder beyond a reasonable doubt, or the evidence proved it beyond a reasonable doubt, it says that, but if you do not so believe, or if you have a reasonable doubt thereof, you will acquit the defendant of capital murder as alleged in the indictment, say by your verdict not guilty, and proceed to consider whether the defendant is guilty of a lesser included offense. And it goes on and on each page, okay? My suggestion is you'll never get past that, based on the evidence. I want to go back and read another section of the evidence that the judge put in the charge, and I want to remind you of your responsibility. I want to remind you that one of the things that I told you that was so unique and special about us and what we do in criminal trials in the United States of America is that we put you in charge of what the outcome is. And the judge has told you that again. I went over it on Monday. I don't want to remind you, because you do have conflicting testimony in this case, no question about it. Okay, but what does it say on page 13? You're the exclusive judges, so the facts prove the credibility of the witnesses and the weight to be given to the testimony. And I think you remember, out of all of what might be in here, that I spent some time on that on Monday for a reason. Because one thing we can't control is whether someone wants to testify and what they will say. I want to talk to you now about why this is just one offense and one offense only, and that's capital murder. I want to remind you all about our setting, and I don't mean here in this sterile courtroom. I mean over at the Schenkel Tower at Methodist Hospital, on the floor, where moms and babies reside for a short period of time. Moms who deliver naturally, or C-sections, or whatever, but especially C-sections. You ain't walking out of bed the next day right away. There are people who go there and attend to that. But somewhere you've heard from the evidence in this case, and it's probably true in every room there, that a mom and a baby together. There's a point after the birth of a child where we all, as parents, we take a moment. There's certainly a reasonable inference and deduction from the evidence, moments from what you've heard, how she treated that baby. That there's a moment where you look into your newborn's eyes, especially your first one, and you see love like you'll never see it before. You see wonderment like you'll never experience. And your wish is for everything to come out with it. Unfortunately, part of that involves who the dad is. And that's why we're here, regardless. You have a staff who works there, social workers who come in and attend to the needs of the mother and the baby, that moment and what for the reasonable near future. You have nurses who come in and make sure, especially that C-section mom, is not suffering from infections or this or that or the other, not having complications, so they can do what? Move them on home with the baby, and so they can continue to live their lives. And that's what was going on. We had people attending to the business of a new life. We had a mom who was there about her newborn, and all the staff who was there to make certain that the new little lives come in and are protected. The only problem, and the problem that brings us here today, is there was another life walking around that made its way into the Schenkel Tower Methodist Hospital, to the floor, confused, you know now on meth, goes into the wrong room, can't get that figured out. You heard David Lopez's description of that. Finally winds up, what's walking around? That love for that baby? No. Rage, resentment, anger, and a plan to kill, based on the believable and credible evidence in this case and what you've heard and seen, was walking around, masquerading, going into that building as a caring, loving father, coming in to see his child and tend to the mother. But you know that's not true. By his own admission, he was full of anger and rage. And certainly the evidence shows that. What do you know? First of all, Selena, she knew exactly what was up. She covered her head up quick, whether it's alcohol or meth or whatever. Intoxicated, out of control. Mix that into that stimulant that the doctor told you, and the doctor told you the kinds of things that can happen generally to personalities, and you listen to her description of him, you listen to that audio and see that video, you hear what he said when he screamed back out of there, and this constant screaming. His body has been taken out of that room across a woman's dead body, and he shot her in the head. And the only thing coming out of his mouth is what? She cheated on me. It's the only concern. Why? Because he's executing his plan to come there and kill. Press the button, get somebody in, I'm gonna kill somebody. I don't know if you caught this, but there was one person that went in there first, before Miss Jackie went in there. And you gotta think, that person that went in and walked out with him in that room with a pistol, that's the luckiest person in Dallas County on that day. She got to walk back out. The next person who walked in to care for the mother and the child and their ongoing needs wasn't so lucky. She gets popped in the back of the head. So now, all of our energy is up. We're going to execute the plan. Press the button. Get them in here. I'm going to kill me and you and them. But, you know, liars lie. He wants to kill himself, he could have done that. What really what the plan was. The plan was to create chaos and kill. Why? Because of anger. Why? Well, what we're told and what we know is this idea of cheating on him, whether she did or not, is irrelevant. That's what he believed. And that overcame everything, that anger, resentment, and rage towards her propelled him to kill other people. Misguided. None of it should be guided towards anybody, but certainly not to those who help us. And then what do we know? We know that Miss Flowers, unfortunately, walking down the hall, you see that body turn. You hear one shot, you hear a second shot. Where's that second shot hit? Right in the neck. A fatal, deadly spot. A fatal, deadly shot that she was never, ever going to survive. In fact, you saw in the video that they were trying to give her CPR right there, right down at the nurse's station. That's how fatal that was. What else do we know? Well, we know that somebody who had left, interestingly, the only conversation about this, had left a gun, allegedly, which is a bunch of nonsense, I'll suggest to you from the evidence, a gun in somebody's bag. There was more to it than that. Because there's the ability, willingness, and the act of taking that clip out and putting some more projectiles in. Okay? Is that true? Yes. Why? What did he have with him? All these extra projectiles. Why? Well, if you go in there to kill, okay, you can't run out. The only problem is the whole escapade is wrong. Fortunately, there was a police officer right there who shot him. Okay? What else did we bring? We brought you evidence from Selena about being pistol whipped. We showed you the pictures. Then we did more than that. We did more than show you the pictures. We brought DNA evidence of the hair on the gun. We brought DNA evidence to prove this. We brought MEs who told you how these people died, the angles, and all of it is consistent with what Selena said, what Officer Rangel said, what the scientific evidence shows, and it all brings it together that in this case, this is capital murder, and it's capital murder because, as the judge tells you, a person commits the offense of capital murder if he commits murder as defined above, and the person murders more than one person, A, during the same criminal transaction. You got to hear and see from Officer Rangel's body-worn camera the sounds, the time, the gunshots. You didn't get to see Jackie get shot, but you certainly saw Miss Flowers walk past that room in the wrong place at the wrong time. If only she had been 1, 2, 3 rooms away, maybe on another floor, maybe on a break. The same thing for Jackie. Somebody would probably be dead, but maybe we wouldn't be trying about these two. Because, like I said, I think it's painfully obvious and clear beyond a reasonable doubt that he was on a mission to kill. And he accomplished his mission. He got shot in the course of it, something he probably wasn't expecting to go and find a police officer, just taking a police report on a theft right down the hallway. And we have him here, and we brought you this case. And we're asking you to do what you told us you'd do. First of all, when we asked you to take that oath the judge did, you told us you were serious about it, you meant it, you were gonna give us true answers. And we went over all kinds of things. Okay? We're counting. You stood up, you took an oath, and you said you were going to render a true verdict according to the law and the evidence to help you out. We trusted you, and we're counting on you. And what we're telling you is our position on this case, the position that's proved beyond a reasonable doubt, is that this man, as I said, was walking resentment, rage, anger, with a plan to kill. And he took all of that into that place for new life, new birth, new hopes, new plans are the only things that are supposed to reside in that tower. And what he took in there was death 2 times. And you've heard all the evidence, cross-examination, replayed the tape. You heard what he said. Not often you get to come down here on jury duty and hear and see death distributed out in a random fashion like what he did. But unfortunately, there are those who will do it. And when you were sitting from here to there, whether you realize it or not or thought about it, you were sitting just that close to a murderer, a capital murderer. who shouldn't be played with, shouldn't be second guessed, and look at the facts and reach a reasonable conclusion. And based on these instructions, as I said, if you read them, you should never go past capital murder. Because that's what the believable and credible evidence shows in this case. He's guilty of capital murder, and we're asking you to follow these instructions in your oath and find him guilty. Thank you.
Thank you, counsel. Anything further?
Yes, Your Honor. Please, the court. Counsel. Good morning. It's kind of like when we started, it was a little bit better for him than me that last time. I thought I'd be saying good afternoon because you know how long you took when we went through Boyd Dyer. So first thing I want to do is I want to thank you all. On behalf of Mr. Hernandez, Mr. Johnson, myself, thank you for taking the time out of your schedules. We know that it's difficult to come down here, leave your lives, and listen to cases like this. And we appreciate it, and we appreciate you doing your duty and sitting down here. And like Mr. Cuozzo, we are going to rely on you, rely on the oath that you took to follow the law and the evidence and let it lead you to the correct verdict. Obviously, we have a very strong disagreement with them on what the final outcome should be. But as Mr. Johnson said in his opening statement, we are not saying he's not guilty. That's not what you're here about. It's about determining to what level he is guilty. That's why during voir dire, I brought up with you the lesser included offenses, so that you would understand how the process worked and what you would be looking at. And we talked about, if you remember when the judge's first case came in, and when I talked to you, I asked you, who came in here and thought, I wonder what he did? Now, when I asked it, nobody answered, nobody raised their hand, because she had already asked it and gone over it. That presumption of innocence that we were talking about goes throughout your deliberations as well. And you might be wondering, well, what does he mean by that? Well, if you go back and you look at page, let me get it here. It talks about, when you're applying the laws of things, it talks about your application in the presumption of innocence. And when you go down, and if you has a reasonable doubt as to which offense, whether it's capital murder or murder, the presumption of innocence applies so that what you will resolve that doubt with is a finding of the lesser included offense. And I want you to know that because sometimes you think, well, presumption of innocence, that's gone. We've already passed that. We've presumed him innocent, and so now we can just, no, that presumption goes through the rest of the case. When you're looking at the lesser included offenses, you still reserve that and use that to determine a lesser included offense as well, such that that doubt would be resolved in the defendant's favor. And that's very important to remember here because you're looking at a number of different possible verdicts on your behalf. So please keep that into consideration. The other thing we talked about was the burden of proof. We talked about the fact the state does the accusing, they have to do the proving. Which means a couple of things now. First off, it means what you've seen throughout. They get to start the case and they get to finish the case, okay? Which means we'll get up here and we'll argue, and after we sit down, they still get to stand up and respond to that. Note, we would love to get up and respond to whatever they say. Keep in mind that for every argument they have, there's another argument to be made for the other side. What we're asking you to do is, as you took your oath to consider all the law and the evidence, is to give both sides a fair shot. Listen to the evidence, look at the evidence, apply it, and then come out with the proper verdict. That's the oath that you took, and that's the oath that we're holding you to. But realize, we would love to get up and respond, so we're going to have to rely on you all back there to think about what would the retort be? What would the defense come back and say to this? Doing that would give everyone a fair verdict in this case. We also talked about actually we didn't talk about this, I want to talk about it briefly. Communication, the hardest thing for a juror to understand is how to communicate with the court. It might seem simple, it might seem that you just send a note and that's it. Well, no, that's not quite it when you want to have testimony read back to you. There has to be a conflict with that person's testimony. You have to identify that conflict and that person and send a note out to the court with that information. That's the only way that the court reporter can then go and read back that information, and it'll be presented to you in a number of forms. It could be read back to you, or it could be printed out and given to you. But unless you point out the conflict that you have, you will not get the response that you need. I want to point that out because most times that's an issue. You all want to hear what you want to hear. You need to know how to get that information, the proper way to get that information. And if you don't ask it properly, you'll get a note back that says you have all the law and evidence. Well, then you'll know, well, we didn't ask it properly. Okay, so keep that in mind, all right? Last thing I want to talk to you about is what I discussed during voir dire, was respecting everyone's decision. I talked to you about the fact that I picked out 3 jurors, and I said, 2 of you think he's guilty, 1 of you think he's not guilty. What would you do? Would you beat up on him? We talked about 12 angry men. We actually had one of the jurors, if you remember, that actually played a part in that, as a female played a part in that. I want to point that out because that's where you are now. You all are each entitled to, or required to deliberate, but you're each entitled to your own personal moral decision. If you've deliberated and you've come to your own personal moral decision, you have an absolute right to stand by that decision. And you have a right to be respected by all 11 other members of the jury. You took an oath, and we discussed it for this very part right here. Each one of you is the exclusive triers of the fact. Okay? Each one of you, this is a group that has to come to a unanimous decision, but each one of you is the exclusive judge of the triers of fact. You make that determination. You do not have to be bullied, you don't have to accept it, and all of you promised me you would not let that happen, and you would stand by even those people who might have a contrary opinion to you. And we're going to hold you to that. Now, I wanted to come up here and talk to you about these brief aspects of the law. Mr. Johnson's going to come up and talk to you about how the law applies to the facts and give his summation of the evidence that you saw. I appreciate your attention. I appreciate you giving Mr. Johnson the same attention you've given me. Thank you.
Next, please, court. Counsel. Ladies and gentlemen, I too would like to thank you for the time and the attention that you've given this case this week, and the fact that you've taken time from your life to sit here and have to listen to some pretty brutal things here in the courtroom. A lot of these things, it'll take you probably not days, but weeks or months so to soften those things that you've seen and try to set them out of your mind. But we appreciate your being here and doing your job as jurors in this case. I too want to start off by talking to you about the voir dire process in this case, wherein you were selected to be the ones who hear the case. And I thought it was a real good way that Mr. Creuzot spoke to you in regards to the fact when we were talking about your being the judges in a case, and whether or not you could sit in judgment on another individual. Mr. Creuzot told you to take your focus away from being in judgment of the defendant, but being in judgment of the case that they brought to you, because the question here in this case is, have they brought you everything that you will have to have to give them the verdict that they are asking for? Now, I want to make sure that everybody understands something. When we started off this trial, we started talking to you about, well, it's capital murder. They talked about that. No one really discussed anything about lesser offenses until Mr. Peel got up before you in the voir dire process and told you that it may not just be capital murder that you consider. If you recall, when I gave you my opening statement, I told you that I believe, when you heard all the evidence in this case, that if you would keep an open mind throughout this process, the entire process, certain things may come to you to assist you in deciding the ultimate question is, what exactly is this defendant guilty of? And I told you then that I thought he would be found guilty, or that he should be found guilty of a lesser included offense, possibly murder. Now, just so that you know, because you're not down here every day, this is your day as a juror. You're not professional jurors. We are down here every day in the legal profession handling these cases and dealing with these issues, but you don't see those. So just because this case starts as a capital murder doesn't mean anything about where it should end. The ending point of a trial is decided by the jurors. And it is decided by the choices that the judge gives to you. And you see now that although when this case started, the only thing discussed was capital murder, we see now that we have various destinations that you can arrive at in your deliberations of what you've heard in this courtroom this week. It could be capital murder. It shouldn't, but it could. It could be murder. It could be manslaughter. It could be negligent homicide. Now, where do these come from? Well, they come from an understanding that the law gives us that a person should truly be held accountable for only that which was in his heart when he acted. The mental state. What was happening with that person, and where did that person's mental state take him? You don't judge merely by the result of the conduct, because if that was the case, all they would have to do is stand here before you, show the two deceased, put the autopsies on, and say, well, this is the result, this is what he caused, and so the verdict must be that. But it can't be. That's why we have trials. That's why we have trials. And they took on the responsibility in this case, repeatedly told you, they take that responsibility and they'll live with it. And I submit to you that they have failed to do that. Now, as I stand here before you folks, if you think that I would not stand here for a moment and argue that this defendant should be absolved of accountability for his actions. Absolutely not. But what is the appropriate verdict in the choices that you have before you? Capital murder. If you recall in voir dire, this case, when the judge finally told you what the defendant was charged with, she said it is capital murder, the highest charge in our land. 2 punishments, life or death. Life or death. And she told you that this case was not one involving an allegation or a request for a death sentence. So it still is life without the possibility of parole, the ultimate punishment in the case in our state. And folks, when you accuse somebody of the ultimate charge, jurors, if you do your job, if you truly do your job, you should judge them just like they asked to be judged. Did they bring you the ultimate proof? Can you honestly, and folks, you'll answer this question by your verdict, what can you honestly go back there and say has been proven to you beyond all doubt? All reasonable doubt is the standard. Now, Judge Crusoe gets up and he says, and he's got a narrative. I mean, you've seen where their narrative has taken them through what they believe the evidence has shown in this case. And as he stood here and eloquently painted this picture for you of a situation that was preordained, and that he claims the defendant came into this situation that day with a heart bent on destruction, anger and rage, I think was the terms he continued to use. And that as he entered the hallway of the hospital that day, that this was a preordained destination of events. That's his theory. That's his narrative. They are now asking you to judge that narrative. And I'm going to ask you to do that because I submit to you the evidence absolutely does not substantiate that. The evidence doesn't prove that this was an intent by Nestor Hernandez to walk in there and cause this destruction. Now, so let's talk about how could we be here? What brings us here today if it wasn't this preordained destination that the state is adopting as their narrative of this case? And folks, that's where it gets complicated. And you know why it gets complicated? Because life's complicated. Life's complicated. Life is complicated out there for everybody in this room. Life is complicated out there for Nestor Hernandez. People find themselves in situations, in relationships with people. It's not all romantic comedies on the movies. It's real life. And in real life, in this particular case, we've got Selena Bellatora and Nestor Hernandez, 2 people with lots of problems. Lots of problems and a long history between them. Drug use, criminality, cheating, lying, the whole host of things that go on between people that cause the friction and the issues that led to this particular situation. Was it a preordained destination, or was it something that happened in the split of a moment? And think about it, because as the judge told you,
it's not always, they don't know if someone's gonna testify, but our defendant got up there. He asked to get up there to tell his story to you, knowing that he would be judged by you, his credibility, knowing that you would look at his testimony in light of the other testimony that was before you from Selena Villatora. And I submit to you folks that there was nothing about this day that was in the midst of all of the problems that they were having. And he got up there and told you, and I think you could see it, and I think it has the ring of truth to it, because as he described that relationship and told you, she wasn't even gonna let me be claimed to be the father. She's telling me that sometimes I'm not the father, other times I am. I know she's been cheating on me. I'm not 100% sure if it's even my baby, but he's talking about how he goes there that day and the day before. And she wasn't even going to let him take her to the hospital. Now, how do you think that's going to make a man feel? And folks, again, this isn't, I want to tell you these things to put in perspective what took place out there. So he takes her to the hospital. And one of the issues I think is important in this case, and you may not, you may disagree, you may think what I'm telling you is wrong. But again, does it not have the ring of truth? Because Selena Villatora didn't really understand what importance it would have into the picture later. But how would we have ever known that she was holding out that birth certificate over next to Hernandez's head? You get rid of that gun now, or your name's not going to be on there. And he told you that because of what she said, I told her, okay, fine. And I stuck it in her bag and carried it into that hospital. And you got to think about it. Is it this preordained destination? Or was it something that came together in a moment, caused in part by Selena Villatora? And folks, again, I'm going to sit here because I believe that if you really examine the truth of this situation, there's a lot of this that got started, that was started by, exacerbated by Selena Villatora. Interesting, because see, we know from, as the prosecution told you in voir dire, they got to turn over all the evidence. We can see what everybody said on the day this all happened. I asked her, Selena, when you get in there, he's trying to talk to you, and what do you pulled the covers over your head and refused to talk to him, did you? Yeah. What do you think, folks? How is that going to make a person feel? Get out of here. I don't want to talk to you. And then you don't. And see, folks, let me ask you this, because this is a courtroom. This isn't scripted. This isn't television. Why is that important? What did the defendant tell you about her pulling the covers over her head? I really don't remember her doing it. Now, why is that important? Because it has the ring of truth to it. He gets there and he's in this situation that is getting worse by the moment. He says that at that point in time, we're arguing. She's telling me to get out. I get the gun. We start arguing. And as Miss Pakua comes in the room, she starts getting up and, well, I'm gonna do this, and she grabs her phone and starts to walk. Take a couple steps is exactly what he said, away from the bed. And that he walked around to get over there, and when she said, I want him out of here, what'd he do? What'd he tell you? I started to hit her. Okay? Folks, I believe that the evidence in this case shows that that is what is reasonable that took place. Not this preordained thought that he was wanting to kill everybody. And whatever Selena Villatora's story is now about, oh, I'm going to kill everybody that walks in the room. If that was really how he felt, folks, she would have been dead. She would have been dead if that was his ultimate goal. If this was a capital murder, she would have died on the spot. But he says, no, I hit her. I slapped her, and then I tried to hit her with the gun, and while we were going, the gun goes off. He said he didn't even know Miss Pakua had been hit at first. Did you hear how he described it to you? After the gun goes off, she was leaning. She didn't even fall immediately. That's from his perspective. That's what he told you from the witness stand. Now, folks, I'm gonna stop here, right as I talked about the testimony of my client in this case, I wanna remind you of something. Okay? Going back again to what was said by not only the court, not only by the prosecution, but also by co-counsel. They have the burden of proof. We have none. When the defendant got up there and testified, I'm gonna tell you as I stand here right now, in order to find the defendant guilty of a lesser offense, you don't have to believe everything he told you. You don't have to believe everything he told you. The question is whether or not it causes you to have a reasonable doubt about what they charged him with. And they charged him with the ultimate case, and for it to come together for him, they have to have ultimate proof. I submit to you the things that the defendant told you. The gun went off. I had no intention of harming her. I had no intention of shooting her. I didn't want to do that. I was trying to hit this girl upside the head because of the way she was treating me. Folks, that has the ring of truth. Can you honestly go back there and say that that did not happen? Can you honestly go back there and say it didn't happen? And if the truth, when you ask yourself that question, is, as far as Ms. Pakua goes, I don't know. Because he went on to describe as to how he went over and he's opened the door and he just started shooting out the door, which caused, we know, ended up causing the death of Katie Flowers. But the situation at that point in time is crazy. It's crazy. It's out of control. And then we know the next time he steps out, he gets shot. And that's when all this screaming and things take place. But you got to understand, you can't take one moment and then go backwards and say that because of what he's screaming here, he must have felt differently here. That doesn't make sense. If his plan was to kill people, he would have walked in there and started shooting right from the start. That's where their case fails, because in order to get the ultimate crime, they got to convince you that this was what he was wanting all along. And they can't do that, not based on this testimony. The court's charge tells you, look at the mental states. Mental states. Was the killing of Ms. Pakua knowingly and intentionally, or was it reckless? Was it done while he is trying to admittedly hit the mother of his child with a gun in a hospital? And see, folks, and the whole situation's ridiculous. And as I stand here and argue, I know you guys look out here and you see this courtroom full of good folks, good people. And I know that you have pressure to come back and do what you feel they want you to do. But that's not your job here. Your job's to do what's right. Your job's not to do the easy thing. Your job is to do the hard thing. And that is go back and analyze this evidence. Can you honestly say he was intentionally acting when Ms. Pakua got shot? And I submit to you that you can't. And Selena Villatora, her version of what she says happened out there is certainly, I submit to you, colored by the fact that she knows it was her own actions which started this tragedy. Think about it. If you were the one doing things that caused somebody to go to do acts that cause this kind of carnage, would you not try to soften the blow to yourself and those around you by deflecting the blame? Which I submit to you is what she's done here. You have these choices. Was it knowingly and intentionally? Did he say at the moment Ms. Pakua was shot, I want to shoot her, I want to kill her? Did they prove that to you? In light of all the factors, I submit to you that it's just as reasonable that as he told you it was reckless while he was trying to beat his wife or his girlfriend with that pistol. Those go down to the issues of murder. Goes to the issue of manslaughter. Okay? Because if you believe that maybe you don't know about Ms. Pakua for sure because there's parts of this evidence that doesn't sit well with you, or that causes you to only have a reasonable doubt. Not to get up there and say, well, I believe every word of what he told me. That's not the law. We don't have to. You don't have to believe him. You just have to go back there and ask yourself, do I have a reasonable doubt, truthfully? And if I do I have the moral fortitude and the courage to do the right thing? And not only the right thing, but what I swore to this court prior to this testimony starting that I would do. Is it reckless? I submit to you it was. And if you find it to be reckless, then the proper verdict in this case is a verdict of guilty to manslaughter. To manslaughter. Now, you go back there and look at it. It also gives you a choice to find whether or not you believe it to be criminally negligent homicide. Now, I'm gonna agree. I will agree with the prosecution if they get up here and say, Ms. Johnson has to be crazy to argue that. And truthfully, I think it might have to be. Because to get to criminally negligent homicide, I think you'd pretty much have to believe the defendant. Have to believe everything he told you. You'd have to feel comfortable going up and saying, I'm basing this verdict on everything he told me. Now, you may not be able to do that. But I submit if you do your job, the things that he told you will cause you to have definitely a reasonable doubt about capital murder. In this charge, folks, you have lots of choices. Capital murder. I submit to you, you really only have three. Capital murder, murder, and manslaughter. Negligent homicide might be a stretch. But I'm going to tell you, when you go back there, before you vote on anything, reread this charge. If all of you want a copy of the charge, send out a note. We'll try to get you, everybody can have their own copy. You can read it, discuss it together. But make sure you understand what you're deciding when you go back there. Because you're going to find that in all of these choices, every single choice that you have, you're going to have a paragraph between one charge and the next, from capital murder to murder, from murder to manslaughter, from manslaughter to negligent homicide. In every one of those choices, the court's going to give you instruction that reads basically this right here. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either the murder of Jacqueline McClure, the murder of Katie Flowers, or manslaughter of Katie Flowers, and here's the language between every choice you have. But you have a reasonable doubt as to which of these said offenses he is guilty. Then you must resolve that doubt in the defendant's favor and find him guilty of the lesser offense. Okay? That's in every choice that you have. And folks, like I said, you know, you've heard this thing, and as I told you in opening statement, all I could ask for you to do is keep an open mind. And I know that there's not a person in this room that wants to do anything that could be perceived as in Nestor Hernandez's favor after the heartbreak and hardship that he's caused all these folks. But you remember when I first stood up here a few minutes ago, I told you, justice is when you find somebody guilty for what he actually did. They haven't come in here and proven that he intentionally came in there and killed two people. They haven't done that. It'd be easy for you to go back there and do it. But I'm going to trust that you're not going to do the easy thing. Go back there and read this charge. Read this charge. And folks, when you read it and you apply your common sense, when you go back there, and if anybody says, well, wait a second, there's parts about what Nestor said I didn't believe, go back there and think. Just the way he was phrasing certain things, the way he was describing certain things to you, the way things were making him feel. Even though none of you could imagine possibly the horror and the harm that he caused, I submit to you, every one of you could sit there and at certain times go, I think I know how he was feeling. Now, when it led to this carnage, it was wrong. Nestor Hernandez is going to pay for his crime, but he should pay for only that crime which he is guilty of committing. Folks, I'm going to sit down. Mr. Lewis gets up. As Mr. Peel just told you, I don't get a chance to get up and respond. He may get up and say, well, hey, Mr. Johnson, he's over there screaming about this, but he didn't mention this. I'll guarantee you, there ain't nothing he's going to say to you that I couldn't respond to if I was given an opportunity. I don't know exactly what he's gonna about to tell you, because I went over and tried to look at his notes early and he turned his pad upside down. So I'm sitting here guessing what he's gonna say also. But I'm gonna ask you guys to do this, because this is the ultimate allegation. I want you to give the defendant the ultimate presumption of innocence. And if Mr. Lewis makes a point that I haven't addressed, when you're back there to deliberate, I would like for somebody to stand up and say, what might Mr. Johnson's response have been to that point if he had been given a chance? Because I can promise you, folks, what I have told you here from the heart is what we, you, all of us in this courtroom have seen this week. And if you don't believe that this case meets the ultimate definition, not for retribution, because if we were talking retribution in this courtroom today, capital murder would be the easy and quick verdict. If we're talking about justice, the defendant will be found guilty for what he is guilty of, and that is a lesser offense from capital murder. And I'm gonna ask you to take your time to think about it, but before you ever vote, make sure you read the language where the court tells you. If you believe he's guilty of something, but you're not sure beyond a reasonable doubt what it is, you must resolve it in his favor. That's the appropriate thing. Follow your oaths, follow the law, follow the facts, and return a verdict that is justice and not revenge. Thank you.
Thank you, Mr. Johnson. The state ready?
Yes, sir.
Go ahead.
How much time do I have, Your Honor? How much time do I have?
We have 20 minutes. Well, 24 minutes.
Thank you, Judge. If you can give me a 3-minute warning,
I will.
thank you. Before you start my time, can you give me 1 moment to set up the photographs? Thank you. Permission to approach.
Yes.
May it please the court, counsel, ladies and gentlemen of the jury, good morning. So we spent the last couple of days talking about the heinous acts of this defendant, Nestor Hernandez, and the absolute havoc that he caused at Methodist Hospital on October the 22nd, 2022. But I want to take this moment, just for a few moments, to remember and focus on these victims. Jacqueline, Jackie, Bakua, Katie, Annette Flowers. That's what this case is about. They had family, they had friends, they had coworkers that loved them. They were doing what they loved to do on that day, helping others, being public servants. Jackie, social worker. Annette, being a nurse, helping mothers and their babies. Doing what they love to do when they were viciously, deliberately, and intentionally cut down and murdered by this man, Nestor Hernandez. So as we review the evidence in this case, in this closing argument, and when you go back to deliberate on this case, I want you to remember them. Remember them. Jackie and Annette. So let's talk about the credible evidence in this case. Let's start with Selena Villatoro. We know that Selena's not an angel. She's not a saint. And she was honest with you on that stand about her criminal past. However, do you know how you know that a witness is telling you the truth? Because you have evidence, overwhelming evidence that corroborates what they tell you. That's how you know that they're telling you the truth. Selena, she told you. That day, Nestor came in there with a beer in his hand. You saw video of Nestor with a beer in his hand. Of course, he has to admit that. Yeah, she said I was upset with him when I saw him the day after I gave birth to this baby. He walks into the room with a beer. So I covered my head and I didn't talk to him. She was upset, and rightfully so. She says he becomes enraged, starts accusing her of not only cheating, but having somebody in the room at that time. He begins checking the closet, checking the bathroom. Of course, there's nobody there. But what does he do? He begins to pistol whip her multiple times with the gun on her head. He flips over the table, spills the beer, right? Evidence. Evidence corroborates everything that she's telling you. She's got visible injuries from this assault. Multiple visible injuries. So of course he has to admit that he assaulted her, struck her multiple times in the head. He has to, because what she's telling you is true. We got the hair on the gun. As the DA said, we tested these hairs. They're Selena's hairs all over that gun. Multiple strikes to the head. He says, we're going to die today. Enjoy your time with your baby, because we are going to die today. And the next person that comes into this room is going to die with us. Unfortunately, that was Jackie, doing her job, helping. And what did Selena tell you? The defendant got up off that couch with the gun in his hand, walked right up behind her, shot her in the back of the head, point blank range. But what does he do then? We'll get to his statement, talking about this was an accident and he didn't know what to do. What does he do then? He goes to the door. He fires out the door twice, directly at Annette. Now you notice the defense attorney didn't even mention Annette. He didn't mention her at all in his closing argument. Why is that? Because the defendant's statement is so absolutely ridiculous. And we'll get to that. We're going to pick that apart too. Let's start.
What, 10 bishops? Got emergency traffic.
What did you hear? You heard the first bang, and then you heard a thud. That is the body of Jacqueline Pakua hitting the ground. Disproving what he says, that she didn't fall. You heard it yourselves just then. He goes to the door. He claims he's not looking. You can look at that video and tell he's pointing his gun. He raises it, points, and fires, not once, but twice. Bang, bang. You see Annette standing right in front of that door. There is no way possible that he did not see her when he fired that gun. Not once, but twice. Okay, so what did, more credible evidence, what did Sergeant Rondell tell you? Well, even before that, Selena says he reloaded the gun. Oh, I didn't intend to hurt anybody. I didn't intend to do anything with that gun. Really? You got a gun in your pocket? Not only the gun, but you bought some extra bullets as well. Extra bullets. A box of bullets sitting there in that room. See, the credible evidence is starting to pile up. He wants to sit up here and say that this defendant shouldn't be absolved of his responsibility, but then he lays it out on Selena? Really? Okay. Sergeant Rangel, what does he tell you? He hears the shots, he responds. Thankfully, he wasn't hit, because he was standing right to it, Ned. He retreats, he calls for help. At that moment in time, the defendant comes outside of the room with the gun still in his hand. And he is forced to fire to protect not only himself, but others. Because as Selena told you, he was hell-bent on killing more people. Push the button, push the button. Nah, she refused to do it. He was trying to get somebody else in that room to kill him. Sergeant Rangel, like I said in my opening statement, thank God he was there, because he definitely saved additional lives that day. And how do you know that the defendant tried to come out of that room? That's the bullet that Sergeant Rangel fired. Went right through his leg and lodged into the wall. That's how you know he tried to come out that room. Plus you saw the video of him trying to come out as well. Credible evidence. Add up. All right, let's get to the defendant's statement. I'm not gonna even waste my time, waste your time talking about this whole back and forth with Selena, the cheating, the STDs, and him not believing the baby was his, because you have his medical records and evidence, no mention of any STDs. You also have the DNA test proving he's the father. Let's not waste our time with that. He wants you to believe that he goes into the room, and with his word, they begin to tussle. Him and Selena. Selena, who had a baby the day before, not only had a baby, she had surgery. She had a C-section. She told us that she was in a lot of pain. But he wants you to believe that they're in there slapping and fighting each other. Not only is she in pain from the C-section, as you saw on multiple body cams, she's hooked to an IV. She can't move around like that. But he wants you to believe that he's in there fighting with her, and she's the aggressor. It's not credible. So in the course of that, they're tussling, as he says. He pulls out the gun by his own admission. He says, my finger wasn't even on the trigger. Okay. So he walks towards Selena. He begins, by his own admission again, striking her with the gun. And in the course of trying to strike her again in the head, Jackie walks between them. Okay, we know that that's not credible. Who in their right mind is going to try to stop a fight with somebody with a gun? But that's what he wants you to believe. And during the course of trying to strike Selena, he accidentally discharges the gun. He accidentally puts a hole directly in the back of her head. That was an accidental shot? No, sir. The evidence shows that this was a deliberate kill shot, just like Selena said. Deliberate. And then he fires out the door and he shoots Annette. Oh, I wasn't even looking. Okay, you weren't looking, but you caused that shot right there directly to her face, and you shot 2 times, but you didn't intend to hurt anybody. Okay, sir. Stippling. What did the ME tell you about the stippling? That is burnt gunpowder. You only see that between 3 and 5 feet. Close range. All over her face. Credible evidence. Adding up. Adding up.
Partner! Hey, I'm Robert. What's your name, partner? What's your name? Talk to me. Okay. Okay, listen. We can work this out, partner, okay? All I want to do is just Get the people outside, please. We can work this out. Just let them outside, okay? Just throw the gun outside. Throw the gun out, please. Throw the gun outside. Parker, we can work this out, man. Trust me.
If this was an accident, Selena's not gonna be screaming bloody murder. Telling him to stop, pleading with him to stop. He testified yesterday that after he accidentally shot these women, that he was looking for help. No, he wasn't looking for help. He's talking about he's got a hostage. He's refusing to come out of the room. Now, ain't no working shit out. Y'all already know what time it is. Talking about a plan. The DA's right, he had a plan. He intended to go there to commit murder, multiple murders. The defense attorney talks about, well, this evidence doesn't show a plan. We actually don't have to prove a plan to you. All we have to prove is that he intentionally or knowingly killed both victims during the same criminal transaction. But the evidence, the credible evidence here shows that he had a plan. And let's just be honest about this. At the end of the day, this man is a coward. He's a coward. He's talking about, we're gonna die today. Nah. Some other people are gonna die. Now, I will agree with Mr. Johnson on this, that Selena and his relationship, that's a toxic relationship. They were extremely troubled. I agree with him on that. But their trouble,
Cheating on me. Watch your step, please. They're just controlling the breathing, brother, okay? They're controlling the breathing. Cheating on me.
that's what this is all about. She cheated on me. He brought their drama to these women. They didn't have anything to do with that, which shows that he is a coward. He killed, intentionally and knowingly killed, 2 totally innocent victims. He told you that himself. These women were innocent. They didn't have anything to do with that drama and that mess that he was on that day. Yet here we are. Here we are. The overwhelming, incredible evidence shows that this defendant, Nestor Hernandez, intentionally and knowingly killed Jacqueline, Jackie, Pakua, Katie, and Annette Flowers on October 22nd, 2022. And I just want to close with this, going back to the jury's charge, bottom of pages 4 and 5. In order for you to even go to the lessers, and I agree with the DA, you're not going to make it there. You're not going to make it to those lessers. But in order for you to make it there, you have to all agree. All 12 of you have to agree that he is not guilty of capital murder. You all have to be unanimous on that. So if there's one person sitting back there saying that he is guilty of capital murder, hold to your convictions. Don't waver. Again, the evidence in this case is so very overwhelming. I don't anticipate that you will take very long with your verdict. But again, I ask that you keep these women in your mind as you deliberate on this case. Think about their families. Think about their friends. Think about their coworkers, the people that love them. You speak not only for those people, you speak for this community when you tell him that he's guilty of capital murder and that we're not going to tolerate this kind of foolishness and violence here in Dallas County. I submit to you that the only just and right verdict in this case is guilty of capital murder, and we will await that verdict. Thank you.
Thank you, counsel. All right, ladies and gentlemen of the jury, you now have all the evidence in this case. You have the argument of counsel. You also have the court's charge. However, it's lunchtime. And so I'm going to release you for an hour's lunch. You will return at 1:45. And when you're all gathered in the jury room, please push the red button so we know that you're all there. And at that time, the court will give you the charge and other documents, relevant documents. Your first order of duty will be to select a presiding juror, and you'll have the form here, okay? You're still under my instructions. As you're at lunch, do not discuss with each other. Do not do any research. Do not discuss with anybody else. You are only to deliberate when all 12 of you are in the jury room. Is that understood?
Yes, sir. Yes,
All right. The alternate jurors will be led to a separate room where they will stay throughout the deliberations unless something happens with one of the substantive jurors. Then we will substitute. Otherwise, please do not go contrary to any of the instructions that I've given you. We do not want a mistrial in this case. And as I said, push the red button when all of you are present. If you need a break, push the red button and the bailiff will come and attend to you, okay? All right, we'll see you at 1:45.
All rise.
hit play, John Crusoe, if you want me to.
That's fine. All right, we're on the record. Let the record reflect that both sides are present. The jurors sent out a request for exhibits admitted as evidence, and they requested specific as evidence footage of Officer Rangel's body cam, the hospital surveillance footage, and I will send those items back to you.
Okay.
Does either side have any objection?
No, and my understanding, so they're talking about the hospital footage when he walks in, and then the Rangel's body camera, is that what you understand that to be?
Rangel's body cam, and hospital surveillance footage. So any exhibit that contains hospital surveillance.
That's all good.
Yes. All right. I'll put this in. So Stacy, did you get those out for me?
Yes, Judge. Do they have something to play them on?
Oh, that's the other thing. Can the state provide a clean laptop for the jurors to be able to watch?
Okay.
on the record. Let the record reflect that the defendant is present with his attorneys, the state is present, the jurors are present and seated. Would the presiding juror, Ms. Kitchen, raise her hand for me? Mr., I'm sorry. All right. Has the jury arrived at a verdict?
We have.
Is the verdict unanimous?
Yes, it is.
All right. I will proceed to read the verdict. If the defense will stand for me. In the state of Texas versus Nestor Hernandez, we, the jury, unanimously find the defendant guilty of the offense of capital murder as charged in the indictment. Ladies and gentlemen, please raise your hand if that is your verdict. All right. Let the record reflect that the verdict is unanimous. Does either side wish to further poll the jury?
Nothing from the state, Your Honor.
No, Your Honor.
All right, thank you. Y'all can sit down. Ladies and gentlemen, that ends your service on this case. Having found the defendant guilty of capital murder as charged in the indictment, it now falls on me to assess punishment. So I'm going to release you back into the jury room. You can talk to each other if you want, discuss your verdict with anybody of your choice, because you're no longer under my rule and I'm discharging you from your service. If you want, you can come back into the courtroom as members of the public. You can also wait in the jury room if you want to talk to either of the parties, the attorneys, okay? And I'll address you shortly. So I'm going to discharge you at this time. Thank you.
All rise.
So, the jury having found the defendant guilty of capital murder and the court having assessed punishment at life in prison without the possibility of parole, the family, friends, and the victims, the victim's family has the right to make victim impact statements. The public and the defendant are not to make any derogatory comments, facial expressions, or bodily movements. This is the victim's family's time to state how they feel, and we need to afford them that respect. Does everybody understand? All right, thank you. Go ahead.
Do we just,
Do I just stand here?
or do we go up to the platform?
All right, well, y'all want to do it one at a time, or I thought it was in a group? In a group.
We just wanted to stand as a group, but we have individual
Okay.
statements.
That's fine.
Thank you.
As Annette's niece, your actions have completely shattered my heart. As a nurse, it pisses me off. Annette devoted her life to taking care of people, just like Jackie did. Everyone in healthcare does. We vow to serve others, even scum like you. After you wreaked havoc that day and stole two beautiful souls who undoubtedly were better human beings and more deserving of life than you will ever be, they still saved your life. I hope every day for the rest of your miserable life you are haunted by their names, faces, and the legacy that you cut short. Although you don't care about any of that, you've shown no remorse for anything. What if someone had done this to your mother? Imagine having your heart ripped out of your chest. That's what you did to all of us. We had to sit here and look at pictures and watch video of you violently murdering women that you don't even deserve to breathe the same air as. I noticed that you didn't even look up during the autopsy photos. That again shows what kind of a coward you are. You act hard and like you're bad, but you are nothing but a loser who is never going to amount to anything other than a mistake that your mother made the day she birthed you. Your mother will have to live the rest of her life knowing what you did, and I hope that haunts you. It probably won't, because you obviously care nothing about anyone else other than yourself. I hope that that little boy who unfortunately has to share your DNA never grows up to know what a waste of human space you are. I pray that he lives a life full of love and happiness, a life that you would never have given him. Jackie and Annette will live on in me, our families, and every single healthcare worker that will continue to serve others in their honor. You will rot in a prison cell until hopefully you suffer a long and drawn-out painful death and face the hell that you have coming. I'll continue to live and work and serve others. I will be the best nurse that I can possibly be, and I'll continue to live a life full of happiness, love, and grace. I'll make memories with my family and my friends. You, however, will live your days in a prison cell, where your short, fat self will undoubtedly be made someone else's special friend, where every day they will have their way with you. Unfortunately for them, if the photos of your toddler-sized shoes have anything to say with it, they will be disappointed. Rot in hell.
What's your step?
Yeah, there's a step. As my mother, I loved taking care of other people, so I professionally raised babies for 12 years. I appreciate your concern. Okay. Firstly, I would like to everyone notice that this jacket is no longer just a jacket. This jacket is the loudest respect I was allowed to show my mama and Jackie Pakua. This jacket was worn by my mama for too many years, doing the very thing that cost her her life, her job. This jacket somehow, some way, just so happened to be the very color that Jackie wore doing the same exact thing, her job. I lost my mama because she cared more about your son than you did. You don't care about any of this, like my girl said. If you did, we wouldn't be here in the first place. All of this show here is for them. My mother, Annette Flowers, Jackie Pekua, every healthcare professional across the globe. They do not deserve, nor should they ever have to worry about their safety going into work every day. They're the last community that should have that. My mom, above all else, by choice, was just that, a mom. She was a superwoman to say the least. Single mom that raised 4 kids on her own, working full time, always making sure we felt loved and supported. And I'm beyond blessed that I was raised by a woman who was able to be an adult, show up for her children, her friends, her coworkers, her patients, and anyone within earshot that needed her or just to borrow a little bit of her power. There's nothing I can say to you. It doesn't matter. You're never going to care. But we all show today who she was and have this entire week by the strength that we have had to show and put on ourselves. All for what? You couldn't control yourself for 1 hour, 2 hours, however long you were allowed to be in that hospital. You couldn't walk away. We had to sit there and watch you cry for your mommy after we sat here and watched over and over again how you made sure we will never be able to do that again. I have nothing else to say. Thank you.
Thank you.
I'm Annette's oldest granddaughter. I was 14 when he murdered her. 14 years old. I had to endure the trauma of her being murdered. A middle schooler listening to the detectives describe how you killed her. And now I'm 15, having to relive it again this week. I haven't gone a night without thinking about her. I break down randomly in school, and I have to leave class to collect myself. I cry myself to sleep most nights, wondering how someone could do something so cruel, and you don't even care. How is it possible to be so selfish that you take someone's life? The first few months after the murder were unreal. I would leave my house and everything would be a blur. I would be in class 1 minute and sobbing in the counselor's office the next. I couldn't handle the fact that she was gone. We had to go to her house the day it happened to meet with the detectives, and I couldn't even look at her room. Her covers lying on the bed that she was laying peacefully in not even 12 hours ago. She was one of the most important people in my life. I was with her in Austin a week before she died. She was supposed to be here for so many parts of my life, as your son should be in yours. She never got to see me make high school cheer, and I wouldn't have done it without her. She was the person I needed to thank the most. She went to every volleyball game that she could be at. She was always there cheering me on. She doesn't know that I made the high school team, and she didn't get to see my tears of joy when I found out. She always told me to follow my dreams, and when I told her I wanted to be a lawyer, she was so happy. She always told me about the strength that I'll have to have and the work and the hours that I'll have to put in. She didn't get to see me walk the stage when I was inducted into the college program at my high school, where I'm studying criminal justice. She doesn't get to see me graduate high school, and she didn't even get to see my little sister graduate kindergarten. Anytime I think of any of my accomplishments, I'm in tears. Not tears of joy, but tears of sorrow, because she didn't get to see any of them. I miss her more than words can describe, and the fact that she died so traumatically messed me up in a way that I don't know if I can recover from. My perception of the world is completely shattered. I'm always on edge, scared something's going to happen to me. I miss the girl I was before. I was just a normal teenage girl who wasn't worried about someone coming into a place where I should be completely safe, taking my life. And it makes me sick that you can come up here and give your testimony with absolutely no remorse in your voice. The only thing that you were worried about was the fact that she cheated on you. I have nothing else to say.
Hello, I'm Annette's oldest daughter. I cannot even begin to express the feelings I'm having today. And sitting here, having to relive this nightmare of losing my mom. Not only losing my mom, but hearing the awful details of her tragic death. But I'm going to try my best for my mother. If you knew my mom, you would know she was an angel on earth. She lived for her kids, she lived for her grandkids, and she lived for her patients. You know, the ones that she was caring for the day her life was tragically taken by someone who doesn't even deserve to be breathing the same air as the families in this room. It takes a special person to be a nurse, patient and kind, generous with their time. When we were younger, my mom had 4 kids at home that she was raising alone. She never once complained about how long and many hours she spent at the hospital away from her kids. Her heart was entirely into her career, which showed daily with every mommy and baby she cared for. She also valued the time she spent outside her long hours at the hospital. Being a single mother is not for the weak, especially with the 4 of us. Some years we would have to get up at 2 a.m. on Christmas mornings to open gifts before she had to be at a 12-hour Christmas Day shift at the hospital, pretty much every other year. She had a heart of gold. She was such a selfless person. Here I am before all of you, a mother myself, having to speak about the vicious murder of mine. It feels unreal. At 38, I still need my mother. She was my only parent. I still want to call her every day and ask her questions about cooking or weird health symptoms that my kids or I might be having, questions about my childhood. But I can't. All the while, this monster was shouting out, "Call my mom," while he was being taken into custody. Lucky for him, he can still do that. Unfortunately for me, my sisters, my brother, my kids, we can't ever again. My 15-year-old daughter just spoke and gave her statement, but my youngest was only 5 years old when you took her Grammy from her. Luckily, we have more than enough good memories that we'll be able to keep alive in her going forward, so she can feel the immense amount of love her Grammy had for her. But still, her own earliest memories of her Grammy will always and only be the horrific story and trauma of her Grammy's death, by the hands of someone who should have never had the chance to even set foot in the hospital at all, much less have access to a gun in a hospital on what should be the safest department of the entire hospital. I want to thank everyone here and those who couldn't be here for the outpouring love and support you've given my family and me at this time. I also want to take this moment to grieve with Jacqueline Pakua's loved ones and offer my sincere condolences to them. The death of our loved ones, these hospital workers, was not in vain. They left an impact on this world, and they will continue to leave a mark on all, through the patients they served and cared for, and through the improved safety of nurses around the world.
Thank you. Stacy, do you have a box of the Kleenex here? What? Kleenex?
I don't. I have some in my pocket.
I am Annette Flowers' youngest daughter. I have been at an utter loss of words while trying to describe the way what you did affected me.
It has affected every single aspect of my life. I'm also only 30 years old, the exact same age you were when you took her. And now, just entering the real years of adulthood, looking at buying a house, starting a new career, and finding the person I want to spend my life with. You took the one person I'm supposed to be able to go to for all my life questions, my mom. While I hope your mom never speaks to you again, and in fact, it appears she is not here to support you now, I don't even get that option anymore. There are still times to this day that I will need my mom and I'll go to text her or call her, and the reality hits me all over again. I don't get to share any more special moments with my mom because of you. I didn't get to introduce her to the wonderful man that treats me exactly how she always hoped someone would, someone who's an actual man. I didn't get to take her on the trips I planned and make more everlasting memories with my mom. She doesn't get to see me build a life for myself, and she won't get to walk me down the aisle at my wedding. I've never felt so alone on this earth than the day that you murdered her, and every day since. A part of me died with her that day. I don't understand why anyone would bring a gun into a hospital surrounded by the most vulnerable people on earth, where new mothers are learning how to take care of their brand new life that they created with your own child. You don't bring a gun into a hospital unless you have the intention of doing what you did. You didn't bring pepper spray, a taser, or anything else that's for self-defense without costing someone their life. You brought a weapon that does nothing but take someone's life. I'm now terrified any time I see a gun in public. I grew up running the halls of Mesquite Community Hospital, and now I'm scared of hospitals. I recently had a serious heart event due to the stress of what you did, but I was too scared to even go to a hospital. It took me hours to finally make it to an urgent care, and you did that to me. I just can't comprehend what kind of monster you have to be to not only abuse the mother of your own child, but then take the lives of two mothers from their children all within 1 hour. The absolute disregard for anyone besides yourself is disgusting, and as Georgia already said, you are a coward. She was the only parent I had, and now I have none because of you, and you deserve far more, but you deserve nothing than life, less than life in prison.
Thank you. All right, I'd like to thank everyone in the courtroom, members of the.
Still have another
Oh, you
statement
still
to read.
Just one from the McCool family judge.
All right, very well.
They couldn't be here today. I'm sorry, I didn't mean to talk over you.
Go ahead, that's fine.
I was just gonna say there's nobody that could be here today because they're out of town, but I was emailed one by her brother, Michael Oduro, so if I can read that.
Go ahead.
On the 22nd of October 2022, Jacqueline had left home to the Methodist Hospital to do her job, a job she loved because of her gentle and kind heart. Serving people along her profession, social work was her passion, and she did this every day with love for those she had the opportunity to serve. On the 22nd of October, she couldn't go home to her son Nigel, and Nigel and Jacqueline's family will never see her again because she had been shot and killed by Nestor Hernandez, a man she had never seen before. This senseless and cruel killing of Jacqueline only demonstrates thorough disregard for human life by the man Nestor Hernandez. Without a thought or care in the world, he killed Nigel's mom, our sister, our auntie, and a wonderful person. Throughout the trial, and particularly as he testified, we struggled to find some remorse from this man, some regret, and perhaps some sorrow, even if it was in hindsight, but we found none. All we saw was a heartless man who feels no remorse for the pain he has caused, whose only interest was to create a scenario that this senseless killing was out of some confusion and frustration he experienced at that time. This man, Nestor Hernandez, is a man who just wants to get off the hook. Our pain is deep, and we cannot grieve sufficiently for Jacqueline's death. We think of Nigel, her son, 13 years old, and we pray to God that in his goodness and mercy, he himself will be Nigel's guide. We pray for justice for Jacqueline's murder. We seek justice for the senseless killing, punishment that fits the crime, so help us God.
Thank you very much.
Thank you.
I'd like to thank everyone who's in the courtroom, members of the public, the victims' families, Thank you very much for remaining calm throughout the proceedings. It's been a difficult week. And I hope somehow that you can get closure from this tragedy. But thank you for your grace, and I wish you all well.
Thank you.
All right. Thank you. Come on.